All rise. The Court of Appeals Division 1 is now in session.
Please be seated. We're here in our case once again, SA17-0115, Chapman versus Hopkins. Each side will have 20 minutes to present their argument. Petitioners, you may save any amount of that time for rebuttal, but you'll have to keep track of that time yourself. We have the clock at the podium to keep track of the time. We are recording the argument both in audio and video, so in a couple of days the argument will be available on YouTube. Because we're recording this, please identify your client and yourself when you begin your argument so that we can keep track of things when we listen to it again. We've read the briefs, we've read the record we have, and we've conferenced the case and discussed this quite extensively. So we're familiar with the case. For that reason, when you begin your argument, just launch right into what you want us to know. Counsel, you may begin.
Good afternoon. May it please the court, I'm Keith Berkshire, attorney for the petitioner, Gia Chapman. As you can see in our brief, we broke down our argument into two sections. The first is whether the court had jurisdiction or statutory authority to grant the temporary order at all, and secondarily, whether the facts presented and the evidence presented meet the significantly detrimental standard required under 25409A.
Yeah, counsel, the way that I'm looking at the statute, in order for the court to consider the petition, we're only looking at the allegations in the pleading and in the supporting affidavit. So at least that's my understanding. So the initial determination by the judge is whether those elements are met based on the allegations in the pleading and in the affidavit. That there's no, at least at that stage, there's no evidentiary component. Do you agree or disagree with that?
I'd agree in part, Judge. I think that it's similar to what we have in 25411, that you have to allege it at least enough to get it past a gatekeeper function. I think that the 25409 A1 and 2 go into this, that they can kick it out summarily if they don't even allege that, like we do in 25411, that if we don't have adequate cause to allege a change of circumstance. But this had a hearing, so I think once we get to the hearing, there has to be evidence that you met that.
And there will doubtlessly be other hearings in this case at which I read your brief to suggest there will be further litigation of this threshold issue. As a threshold question, and I have two questions for you on this. Are you sure this is jurisdiction? Our case law refers to this as standing in the normal 25409 context.
I think it's also been referenced by this court recently as statutory authority. In Sheets, you called it statutory authority when there didn't meet one of the other 25409C factors. We called it statutory authority, and in a slight distinction of the Marriage of Thorn case where it was called subject matter jurisdiction. So I don't think it
Is it even relevant? Do you care?
I don't think, I frankly don't care. I think it's the same test under either one. I think it's always been reviewed as de novo. It's always something that could warrant summary dismissal if they don't allege that. And here, again, the only allegation is we meet it.
Okay.
We stand in loco. The affidavit doesn't support that. The affidavit of the child doesn't support that they stood in loco parentis.
Well, let's break that down then. If we have, and for convenience, let's call it statutory authority. If the question of statutory authority is a mixed question of fact and law, and that those facts are subject to litigation, the way I look at this is that there's a burden of production followed by a burden of persuasion. The record, I think, contains enough to meet a burden of production. You may vehemently disagree with whether those facts are true, whether they're sufficient, and you'll have the chance to address that. But nobody put the petitioners here to their burden of persuasion. So why at this stage would we grant relief on that basis?
I don't even think it meets the production. There's no testimony. The most they have in what the real party and interest.
Back up. I would go back to Judge Howe's question. Does there have to be testimony to meet? Because it says the court shall summarily deny. To meet that test you talked about, does it to just get in the door?
I think that the first part of this, if we look at other statutes like 25411, this is to the right to get past even the court setting a hearing. And so it may survive that. But once there's a hearing, I mean, again, all they did is state, I meet this. I mean, we have case law all over, Pridgeon, cases like that say you can't just allege something. You actually have to prove it. And here, I mean, there is no difference in the statute for what you need to prove for a temporary order than a permanent order. I mean, if there's no lesser burden for temporary orders than there are for final orders anywhere in our statute, there's argument why you shouldn't even have temporary orders because you get shorter hearings and you're supposed to prove the same thing. But there's no difference.
Strong argument. The temporary orders might be a procedure subject to abuse, but there are some differences. For example, recently this court in Gutierrez said that the 25403 findings aren't required in the order granting temporary orders. You're familiar with that, I'm sure.
Again, and I am. This court cites to a prior case, the Reed case, about the necessity of those towards modifiability under 25403 and 25411, which I understand. However, again, this is one of these things that there's actually nothing in the evidence. They presented nothing. And I think it's important to look at how the court looked at this case when it came in. The court actually, in the first couple pages after the hellos in the minute entry or in the transcript, tells mother that she has to go first because, and the court states, if you don't put on anything else, I'm going to keep the order in place because of what was in the affidavit. That's not how emergencies work. They actually still require due process and actually the person who is alleging something to prove it. Here they didn't prove one of the key factors. I mean, if we look at Reapy, if we look at Downs v. Scheffler, they're required. I mean,
well, they submitted evidence on one of the key factors, or on the key factors. There was evidence in the form of a declaration attached to the petition. It is not improper procedure to say, okay, I view this as meeting the burden of production. In the interest of efficiency, let's give the opponent the opportunity to be heard on the issue. That is due process, isn't it?
Well, it would also imply that we could do affidavits and summary judgment and not need trials. I mean, that's the exact same thing, that there's a declaration or an affidavit attached to a motion for summary judgment that when you get to the hearing, you still have to...
The moment you get two competing affidavits, you need a trial. On summary judgment, if you have one affidavit and nothing opposing it, and that one affidavit is otherwise sufficient to meet the burden, you get summary judgment.
But here, the most that can be read, if we're reading that the pleading, that their verified petition that says we stand in loco, that's all they have. There's no testimony of how. I mean, if we apply the standards of these cases, Reapy and so forth, they have to show how they meet a parental role and are viewed as a parental role. Even their affidavit, their affidavit might as well say we win, because it doesn't say anything beyond a merely conclusory statement about the statute itself. It doesn't say how. It doesn't say in any way how they meet this legal standard.
Well, but I'm confused about this. If we're talking about what the statute requires, the statute says that unless these things are alleged and supported by an affidavit, it shall summarily deny it. What you're talking about is no evidence to support that, and that seems down the road from where we are when we're just looking at the petition.
Well, and I would agree if we had filed prior to a hearing, if there was a motion to dismiss that was denied and this was a special action on a motion to dismiss, that it might survive that test. But that's different than here. We've had a hearing. They have to present their case. I mean, the case law is they have
temporary orders. And I would take your example and move it to the other side of the continuum. If this were a final order and this is the only record you'd have a very easy argument here, because I agree with you. There is not enough evidence on this record to support a final order. But the temporary order.
But again, that goes to my argument. There's no different legal standard for temporary orders than final orders. There's nothing in any statute that says we look at temporary orders and with less merit or with, we give the court more discretion. 25404 doesn't say anything about applying a different legal standard. It says, in fact, you apply the same legal standard. So they still actually have to prove their case.
The same substantive standard, but procedurally it can't be the same. Otherwise, we would truly have a system where we just did the same case twice for no apparent reason. There is a reason in some cases to have temporary orders, though, and that's when you have exigent circumstances involving allegations of significant detriment to the well-being of a child, which I think, as a matter of policy, we've wisely said, we're not going to wait for the court system to deal with things in its own good time. We're going to offer people an interim remedy, even though that interim remedy may ultimately turn out to need reversal. Do you disagree with that?
I completely agree. However, to look at a temporary order that all you'd have to do is say an affidavit and allege all this stuff. Let's allege abuse. Let's allege they were molested. Let's allege they got beaten every day by their brothers and sisters. And then I have to go to a temporary orders hearing and prove none of it. I made all the allegations. If I can go to a temporary orders hearing by just putting in an affidavit that says, the sky's falling, and they have to go disprove it, that's not how the case law works on who has to prove what they're alleging. We got Higgins that says if you make an allegation, you have to prove it. They didn't prove it. They made an allegation. I mean, otherwise we would send in these huge affidavits.
What didn't they prove? Because there was plenty of evidence that goes to significant detriment.
And
there was abundant evidence of significant detriment. Right?
I'll get to that part in a second, but at least on the that they met in loco.
You mean the definition of in loco?
The definition of in loco under 4011, and the only case I can find that really analyzed that, REPI, that the kids think of you as a parent.
Well,
but if you can allow an affidavit that just says all this stuff and put the burden on the other party to go disprove it, we're not the one making the allegations. They're making the allegation. We have to go in and predict what the court might have seen under this affidavit and try to disprove everything in the hour we have. We're not the one making the allegation. They are.
Well, I get back to the burden of production, burden of persuasion, and I would like you to focus on that formal structure, because once they say we have this relationship and there is some other circumstantial evidence from the inferences you could draw from the wishes of the children to support that, how hard is it to say, for example, these grandparents have never met the children, these grandparents have no relationship with the children? It's not as though at a temporary orders hearing you have to disprove the nuances of the relationship. You're looking for the rough contours, and yet nobody from mother's side challenged those jurisdictional facts.
They did in the response. She said, we disagree that they meet in loco parentis. They did, in the response.
She said, we disagree. But the problem is now we have an
Not saying what
evidentiary.
they said. I mean, they said we meet in loco. We say we disagree. Neither of them are some fact-filled statement, but they're about the same level.
But we have circumstances where the children felt sufficiently in jeopardy or in danger that they turned to their grandparents, whether that ultimately meets his definition of in local parentis down the road. I mean, rising up in question, but for purposes of temporary orders and stopping things so that this matter can get resolved, isn't that sufficient, at least at this stage of things?
If that's the case, there's another route, which then would be at least jurisdictionally sound, which would be to do a dependency, which would then put in different safeguards from that standpoint. But here, I mean, in loco parentis custody cases are basically dependencies by people that have acted as a parent. I mean, it just kind of cuts out one of the steps. I mean, it's the same.
I think you make a fair observation, but legally, let's say this had been done as a dependency, and the same allegations, the same pleadings had been filed. Would the result have been different, at least on this temporary basis?
I believe so, because I mean, 8201 is so specific about what factors you need statutorily to do a dependency, abuse, neglect, and so forth, that this wouldn't even meet them on their face. So,
I mean the result would be different, is in more favorable for
I
mother.
think so, because these don't, I mean, unlike it.
I mean, does the jurisdictional basis for the action vary? Because it seems to me, a lot of your argument is rooted in the Constitution, and the Constitution doesn't care whether you're talking about Title 8 or Title 25.
I'd agree, and I mean, obviously dependency can get around Troxel pretty easily if they meet the standard. But if we go back to your argument about burden of production and persuasion, still they presented nothing to persuade the court. There's literally not a sentence of testimony, not in the kids' interviews with Dr. Lavett, that says anywhere that they thought of them as parents. I mean, they could.
But was their burden of persuasion triggered? I mean, I might. Let's agree.
I think when our client denied it in the response, at least. I mean, if you're talking about competing affidavits, then the denial in the response is equally as important as their statement in the petition.
I take your point. I'm looking at the clock and wondering if you want to switch gears to your other argument.
I do. As far as the significantly detriment, which I figured was where I'd end up spending more of my time.
Always works that way.
It does. The court doesn't have to like my client's husband. The court doesn't have to like my client's religion. They can think he's a crook and she's kooky and whatever, but that's not what the standard is. There was no specific incident. We have one incident, this sucking on an eyeball incident. That's it.
Well, we also have lying to the police about parental status.
If the court
That's
inferred
not a good
that,
fact.
Okay. However, was that my client? Again, they can find against her husband something else, but there was not a fact of anything my client did. And if we look at the end of the transcript.
Well, I don't know how you can separate your client from her husband, because she wants the husband around. And assuming, just for purposes of talking today, assuming that the allegations are true, then the children are harmed by that association.
If the police thought it was important enough, they would have reported it anyway, whether he's the father or not. I mean, the police are mandatory reporters. If they thought this kid was harmed, whether the parent, you don't beat your kid and say, please don't investigate it, and they say, okay. You go in and they send you to CPS. Here they didn't see even enough to investigate anything. We've ran CPS checks. The two things that the court
I'm not uncomfortable with the notion that the courts don't automatically defer to the on-the-scene judgment of police in every case. Are you?
No, it's a lot longer.
I understand that the police made that determination, but that's what court is for.
But reopen the case. Call CPS themselves. Grandparents are free to call CPS by themselves and have them investigated. But again, what we have, even if true, doesn't meet the standard, or it could meet the standard that somebody could, that CPS could investigate and keep Mr. Ogden or even potentially my client's husband away. But there's nothing in the evidence that my client did. I mean, this goes down to a failure to protect argument under basically in a dependency. There's nothing in evidence of what my client did that harmed the kid in any way. What she did, there's blind allegation that she's being tricked by her husband and that her whole family hates her husband and things like that. The court makes these statements
there is evidence,
about,
though, that your client basically told the older children, you're going to have to decide where to live, and did not make an effort to retain the family arrangement, which is not normally consistent with.
There's some statements that in November that the older boys, one who's emancipated and the two older ones, went to live with the grandparents. But again, that doesn't go towards any of the younger ones, girls, or I mean, kids do have to, I want to save at least a minute, they do have to at least look at these kids individually if they meet the standards that we harm the children, like we do in order of protection. Did you harm this specific child? But there's no specifics in these allegations. If this is what it takes, that you could take somebody's kids because, hey, I let the kids were mad at me and I let them go live with the grandparents, and there's an allegation that my new husband's a crook, that's not enough, or that your religion's weird. I mean, we could go through every weird thing of every religion
Yeah. The court's not here to judge people's religions. That's not, I don't think, the issue that's before us.
But in what the court said, the trial court does do that. Whether they say they didn't or not, they make comments about, well, pedophiles could be on Christian Mingle too. There was no statements about this. It was the court clearly did not like my client's husband. But that's not enough. I mean, we got the Higgins case that talks about this court's did. This new relationship, you have to show how the relationship specifically harms the children with specific incidents. They don't have anything specific. And I'll save my 30 seconds.
We'll go ahead and give you a couple minutes for rebuttal, and we'll add 2 minutes to your argument as well.
Thanks, Judge.
Good afternoon, judges. My name is Marcus Reisinger, and I have co-counsel Casey Bowman at the table. We represent Ronald and Claudia Pritchard, who are the grandparents in this case and the petitioners below, but the appellees in this case.
And I'm sure you have your own ideas about your argument. The concern that I have, I think we all have, is the primary argument seems to be that these allegations are nothing, that there's nothing to support them, and that they can't even be enough for the burden of production, and it's the way that we're looking at it. Can you address that?
That was the first thing I wanted to address, Your Honor. 25409 is kind of an odd statute in that it contains pleading requirements, and it also contains the evidentiary requirements that the court will ultimately look at once the pleadings proceed to that point. And all the court has to do, well, first, UCCJEA sorts of jurisdiction, are the kids here? Does the court have jurisdiction to make orders to them? That's clearly satisfied. The second step, the court looks at the pleadings. The court has to find that the petitioner stands in loco parentis in the pleadings, that they've alleged it, and that there's significant detriment.
With that word find, because there's no such finding in this order.
I don't know that that's necessarily true, Your Honor. I don't.
Where does it say the court finds that the petitioners stand in loco parentis to the children? I didn't find that language.
I don't think those specific words are present in the order. I think you're correct.
Where's the rough equivalent?
Well, Your Honor, the court, Judge Hopkins noted that he considered all of the pleadings, the affidavits, the testimony, and all of the other evidence that was presented in making his findings.
As every order says, of course. The court's considered the record, and here's the result. But you can't use the result to say there must have been a sufficient basis. Otherwise, we wouldn't really need to exist. That would be circular.
Well, I think it's clearly pleaded, Your Honor, and I think there is evidence on the record that the court could have relied on in order to reach that conclusion, which he must have made in order to proceed to a hearing at all, much less to enter the orders that he entered after temporary hearing.
And I take your argument to mean that there was an implicit finding, but you started this discussion by saying the court must find. doesn't seem that the court found in any express way the actual elements. It seems to me that what the court did was jump to the merits, and there was a lot more evidence on the merits at this stage than there was on the standing prerequisites. I'm curious why that is. I mean, it wouldn't have been hard to allege in something other than a bare legal conclusory fashion that there's an in loco parentis relationship here, yet it's missing.
Well, I don't think it's missing from the pleading allegations, Your Honor. It is missing from the minute entry itself, but we're in a temporary orders situation here where the judge is hurrying to indicate what evidence he relied on and what evidence he didn't.
I'm not so focused on the order right now as I am on the pleadings.
Okay, well, I'll get to the pleadings then. On appendix page 191 and the following pages in the amended petition, there's an allegation that the grandparents provided daily care for the children for their entire lives, for years. There was also
daily.
that's what the petition says. Your Honor.
What page is that?
It's on appendix 191, I believe.
Your appendix or the petitioner's appendix?
Petitioner's appendix.
All right, hang on.
It's page 6 in the document below, appendix 191, at the bottom of the page, section 22. Petitioners provided what amounted to almost daily care to all 6 of the Chapman children prior to intervention in October 2016.
This is in the motion for temporary orders?
No, it's attached to the petition. Oh, do you have it? Just one.
Yeah, I do.
Yeah, okay.
Now, this was the amended petition for legal decision-making in physical custody filed on March 13th.
Okay.
So that fact is alleged.
Now, it doesn't give any time frame. It just says, I mean, it doesn't say anything about all their lives.
Well, I think it's implied, Your Honor, and I think it was something that came through in the testimony that these grandparents had provided care for these children for their entire lives.
But
And-
again, we're looking at the two-step process, right? I mean, enough to get in the door, the threshold determination of whether the petition with the affidavit sufficient, and then going to the merits. I mean, my concern, I guess, initially is whether this, and would you agree that we're giving this a de novo review about whether I don't know what word you want to call it, not jurisdiction, standing, perhaps, authority, I don't know, whatever you want to call it. Are we reviewing that de novo?
I think that goes to Judge Swan's distinction between the burden of production and the burden of persuasion. I think at the stage of the pleadings, this court does have de novo review. The court can look at the pleadings and say, was there anything alleged that the trial court could have used to give itself standing, jurisdiction, authority? Once that is passed, then I think it becomes an abuse of discretion analysis, because the remaining facts, whether these allegations and the testimony presented are enough for the court to enter temporary orders, that seems like a discretionary finding to me for the court to make. And then the court will look as to whether there was any evidence on the record. And clearly there was here. But again, back to the pleadings. Also in the pleadings, it indicates that the the Pritchards provided full-time care to the oldest 3 Chapman sons and stand in loco parentis to the 3 younger Chapman sisters, who have expressed their preference for living with the petitioners rather than mother. It's circumstantial evidence of the child's view of the relationship, but it certainly supports a finding that these people stand in loco parentis. You can imagine a child who feels that they're endangered and they don't have this relationship with a grandparent or a family friend. They'll probably call the police, or they'll talk to maybe their teacher at school. But these children didn't do that. These children wanted to be with their grandparents because they indicated that they felt that relationship with them.
Counsel, if this is what we have, and then Ms. Chapman testifies or states in the response, that's not true. What's the trial judge to do at that point? I mean, you may have met the burden of production, but what about persuasion at that point?
So I think that under 409A, the court has to ask itself whether the petition itself contains sufficient allegations. And I agree with Mr. Berkshire that merely conclusory statements would not be enough. But this petition contains the conclusion of in loco parentis, but it also contains allusions to the evidence that support that. once the court is satisfied that that standard has been met under 409A, the court is free to set a hearing, either a final hearing or a temporary hearing in this case, which is requested, and then contest the evidence. And in this case, mother's only dispute of the in loco parentis status comes in her pleading. So I think the pleading standard has to work in both directions. If her only attempt to refute this affirmative evidence is, well, they don't stand in loco parentis, but they have actually put forth additional evidence, I think Judge Swan, earlier observed that that would be enough for summary judgment. And at that point, again, I believe it becomes discretionary. Judge Hopkins correctly allowed this to proceed to a hearing. He heard evidence and found, based on that evidence, that the relationship existed, and then he entered these orders. Really, I think that, in a way, this jurisdictional statutory authority argument, whatever we're calling it, is somewhat of a red herring, and it's an attempt to get this court to retry the case under a de novo standard, when really we know from the KS versus Marquez case that two courts could view the same evidence and disagree. That doesn't amount to an abuse of discretion.
Well, counsel, assume for the moment that the court was correct in holding an evidentiary hearing in this matter. There's no allegation or finding, I think, that mother is unfit, at least at this point. There's a strong presumption that a fit parent should control and have custody of the child. How did you get over that based on the short evidence that you have here?
So, Your Honor, the fitness standard comes from Troxel versus Granville, which stands for the idea that the state cannot impose itself on a parent's preferential decisions as to child rearing unless there's a finding that the parent is unfit. But the 25409A statute doesn't really say anything about the fitness of the parent. And I think the court could entertain a scenario in which a parent is a fit person. They could be choosing to make good decisions and making fit decisions for their children, but they're not doing that. And I think that's what this statute allows. It's worded in a way that the analysis is not centered on the fitness of the parent. It's centered on the status of the child's safety, well-being, and so on.
But doesn't this statute have to be construed in accordance with Troxel? Aren't we bound? I mean, we have the U.S. Supreme Court telling us what the law is with regard to parent-child relationships.
I guess my point, Your Honor, is that fitness is not a status that a parent receives and then keeps forever. I think the court is asked to make a snapshot finding based on the pleadings and the evidence before it. Is this parent making fit decisions today? And are these children in a detrimental situation today? And I think that's...
And is that consistent with what you read in subsection B about the merits, about the rebuttable presumption and being overcome by clear and convincing evidence?
I think it is, Your Honor, because once the court has found that it would be detrimental to the child to be in the parent's care, again, I can imagine a scenario where the parent could remedy those problems, and the court may think, well, it qualifies as significant detriment for pleadings purposes, but I feel as though I can order alternate safeguards, counseling maybe, or some kind of therapeutic intervention that will prevent these children from being in danger. But if clear...
Or could you find that after hearing evidence, there really is no significant detriment, even though it found it earlier?
I think the court could certainly find that. I think the prima facie pleading standard that's contained in the beginning of the statute doesn't prevent the court from holding a hearing and finding otherwise later on.
I would be careful about reading fitness too much out of the analysis, because in a case law sense, we've already crossed that bridge, right? We have the Goodman case, which essentially allows fit parents to make really bad decisions without court intervention so long as they don't cross that threshold of significant detriment.
Well, I don't think...
In this case,
Sorry.
It sounds to me as though you're trying to raise the fitness issue. Are you?
I think what was raised below and will continue to be raised, Your Honor, is that the children were in an environment that was detrimental to them. And a child could have a perfectly fit parent, but if the parent's environment is detrimental to the children, then this analysis could still.
So are you conceding fitness and just arguing detriment?
Do you need to concede fitness? Does fitness matter at this point?
Yeah, that was going to be my point, Your Honor. I think at the temporary order stage, it's not necessary for the court to make a finding of unfitness.
I understand. I'm asking for your position right now as we consider this special action. Is fitness part of the analysis or not?
It is part of the analysis, and there was.
Or contesting fitness?
There was evidence presented of unfitness at the trial court, so that is a contested issue here.
So your client's position right now is that mother is not a fit parent? I just don't want to misunderstand you. I'm not trying to put words in your mouth.
Yes, Judge.
Well, then,
But if I could you answer that? It's a yes, no.
Yes.
Okay. Yes, you are contesting it.
Yes.
Okay, I'm sorry to interrupt.
so if you lose on that issue, do you lose then?
I don't think that's the end of the analysis because, again, I think the court can entertain a scenario in which a fit parent chooses to be in an environment that's nonetheless detrimental to the children.
Then
Is that a bit inconsistent?
Well, the court could certainly find that if a parent elects to be in a dangerous environment and doesn't want to remedy that, then that means they're per se unfit.
I thought that you were saying fitness doesn't matter because if the child is in a situation that causes the significantly the suffer significant detriment, it doesn't matter whether the parent is fit or not. If that's the case, then why are you taking the burden or the position that mother is unfit? She may or may not be, but this is I understand the argument. You don't need to prove that to prove your case. Is that correct?
I don't think it needs to be proven to prove the case, but the circumstances here dictate that.
Well, then, does that change your answer to Judge Swan then?
No, it was alleged and will continue to be alleged that there's a fitness issue here, in addition to the environmental dangers that are not core to mother's fitness per se. Okay. I hope I've answered the question, Your Honor. So to get back to
Do you agree with Mr. Berkshire that the traditional 403 style best interest finding is not a sufficient evidentiary basis for a decision in a 409 case?
I do agree with that statement, Judge. I think that 409 contains necessarily additional safeguards that aren't present in 403. When you read 403, it's really about two parents contesting legal decision-making and parenting time, whereas 409 is third-party rights. So, of course, there need to be additional safeguards, and they're built into the statute. I don't think that these safeguards, I think these safeguards meet the Troxel standard, but I also don't think that the Troxel standard necessarily applies in a 409A case because the court must find detriment in order to enter these orders to begin with. And I think that similarly, the Goodman case and its analysis of 409E doesn't apply here. And for that proposition, I would cite State versus Gonzalez, which says that if the legislature included a term in a part of a statute but did not include it in another part of the statute, the court cannot read that term in. So specifically under 409E, in deciding whether to grant visitation to a third party, the court shall give special weight to the legal parent's opinion of what serves their child's best interest and consider the factors. That's specifically limited to visitation, which is 409C, not 409A. And I think the legislature must have intended to do that because if you look at the prior 409 and 25415 prior to January 1st, 2013, subsection E didn't exist. There was no...
You're not suggesting there should be a lower bar to give somebody legal decision-making versus visitation?
It's a different bar, Your Honor, not a lower bar. Because
how would you express it then?
Because I don't think the court is required to give weight to the parent's preference if the court finds that the parent's decision-making is detrimental to the child. So I think it's a different analysis. It's a different bar that must be crossed.
It sounds like a very similar analysis. It sounds like you're expressing the analysis from Goodman, which wouldn't surprise me, honestly, because we're talking about visitation through the looking glass here. At this point, we're talking about mother's visitation, right? Because things have gone so far under these temporary orders.
I'm not sure I follow, Your Honor.
Okay. Maybe it was badly stated. But when you talk about significant detriment, it seems to me that is the touchstone under E, and it is also the touchstone for legal decision making. And we couldn't have anything less than a significant detriment standard for legal decision making. Would you agree with that?
I don't agree that detriment is a touchstone under E, Your Honor. I think that's specifically for a visitation case, and the factors that subsection E and its following subsections describe are all the kinds of decisions that a fit parent ought to be allowed to make under the Troxel analysis and Goodman and so on.
I think doesn't Goodman read detriment to be the touchstone under E?
Perhaps I'm not familiar enough with the nuances of the decision, Your Honor, but
Okay.
Focusing on the statute itself, when the legislature combined the old 409 and the old 415, they added in the subsection E language, likely to comport with Troxel, and then the Goodman decision keyed in on what that actually meant in practical circumstances. But the legislature could have chosen, and did not, to say that in deciding any case under this subsection, rather than just visitation, then the court must give special weight to the legal parent's opinion. And I just don't think that's a logical conclusion to make if the court has already found that the legal parent's preferences are putting the children into a detrimental situation.
So, do your clients have to prove as fact in terms of persuasion that the children suffer significant detriment rather than it's just in their best interests?
They will have to prove both, Your Honor. They'll first have to prove that there's significant detriment, it would be significantly detrimental to the child or children to remain in the care of the legal parent. And then under 409B, there's an additional hurdle, that there's a rebuttable presumption that awarding legal decision-making to a legal parent still serves the child's best interest. So I think the court could, in theory, bifurcate physical custody of the children versus legal decision-making, or could award both to the third party. But in order to do so, it must find by clear and convincing evidence that awarding legal decision-making to the parent is not consistent with the child's best interest. That, I think, is where your 403 analysis becomes important. And again, on temporary orders, the court's not required to make a full 403 analysis. But once the court reaches this point of, is there proof by clear and convincing evidence that the best interest standard is being met, then the court's going to look for, well, what's best interest mean? I'm going to look to 403. I'm going to make requisite findings there. And in this case, Judge Hopkins cited all of the sections of 403, and he made a fairly detailed analysis. It's a 7-page order on temporary orders after a 2-hour hearing.
So you could have a situation where if you apply the best interests analysis, it may be in the child's best interests to not be with mother, but it wouldn't overcome the presumption and the significant detriment.
I can imagine that scenario, Your Honor, and I could.
We'd be acting against the child's best interests then.
No, I think if the court could find that it would be detrimental for the child to be placed in the care of the parent, but still find that the presumption that the parent's legal decision-making should remain intact. And I think the court could even bifurcate.
That work.
Well, I think the court could even bifurcate the components of legal decision-making. They could say, this parent isn't making good medical decisions, so we're going to give medical legal decision-making to the third party, but they're still making okay religious decisions, so we'll honor their religious choices.
How does the court make that kind of fine distinction? So that concerns me.
Well, I think it would be a highly fact-specific scenario, and likely won't present itself in most cases, because it's likely that in most cases, if the court is finding significant detriment, then it's also finding this best interest under 409B.
So would you be happy with some sort of fine distinctions here in terms of custody and legal decision-making?
Not in this particular case, Your Honor, because I think there's enough evidence to satisfy both the detriment and the best interest standards here, and that these third-party grandparents should have all of the legal decision-making and the physical custody. I can imagine, again, a scenario where the circumstances might dictate a more nuanced result, but this isn't that scenario. And I've
One last question.
run out of time.
Did the court here enter sole legal decision making, or just legal decision making? I mean,
I'm not sure, Your Honor.
because there's a statutory definition.
There is a
There's
distinction
difference in
between the two, and
distinction. Okay,
I'm not certain.
I believe, I didn't think it was sole, but, okay, thank you.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, Keith Berkshire for petitioner. Not to correct you, Judge Swan, on the case you authored, but the words you used was substantial impairment and substantial harm in Goodman, not significant detriment.
Trying to stay consistent,
yeah.
but you're absolutely right.
We have a lot of S in these. This court in Grayville actually discussed the difference, and in reference to a juvenile case, Coconino Juvenile J5666, I think was the number, said that because visitation impacts the parents' rights less, it's less than a in loco custody order. So this court has already said that we use a lesser standard for visitation cases, so substantial harm has to be the lowest this court could go, based on this court's prior rulings. My clients did also, exactly in their response, rebut what was alleged in the petition in paragraph 22 and app 222 of our petition. They stated, no, you didn't provide daily care, and made it a contested issue, which would go towards the burden of persuasion on this, that we don't think...
Could the judge believe the grandparents over the mother on that issue?
Again, we don't think there's any evidence, besides this declaration of their petition. There's nothing presented, not a testimony, not a single witness stated that they, I mean, in loco, when we read 401, when this court has looked at it in REPI, it's not only that you've acted as a parent, but you're treated as a parent. So even if you allege that you've acted as a parent, there's nothing that says you've been treated as one. And this argument that they've met it since October, I mean,
Well,
we're 3 months
though,
at that point.
Let's assume that the record is pretty flimsy on in loco parentis, but not non-existent. Not non-existent. What's the remedy? Is the remedy the summary dismissal under 12409A, or is the remedy perhaps continuing the hearing and allowing more time to litigate the issue?
Ours, we'd allege summary dismissal, that they didn't meet the burden,
Well,
as
I think
this
you
court did in
acknowledged
Sheets.
earlier. You acknowledged earlier, though, that on a motion to dismiss, this might well pass muster, right?
Correct.
That's
But a motion-
summary dismissal.
Oh, okay, well, I view dismissal from this court a little different than summarily dismissal.
Sometimes we use words
Yeah,
that are
so-
nearly synonymous.
I would say dismissal from this court, not summarily. It was after a hearing. They didn't meet the burden that they had to prove they met in loco, or that they met significant detriment.
Well, but where does it say that they have to prove that, especially at a temporary orders hearing? 25409 says the court shall summarily deny a petition, meaning you don't even get to hearing, unless it finds that the initial pleading establishes that all of the following are true. It makes no provision for a responsive pleading that contradicts the initial pleading. It has no requirement that the court make that finding at a temporary orders hearing. It even has no requirement that it make it at a final hearing, although I would certainly agree that it better do so if it's going to enter a final order to that effect. So procedurally, where's our bright line here at this stage of the case?
I'd ask if I could
Of
respond,
course.
since I have no time. Again, we've never held there was a distinction between temporary and final orders. This court has said in loco case that you have to prove it. I mean, the REPI court said you have to prove it at the hearing. Downs versus Scheffler, you have to prove it at the hearing. So from that end, the same as custody, you still have to prove it. I guess if someone who was putting forward any type of case could allege it and didn't actually have to prove it, I'm not sure our justice system, I think it's such a fundamental tenet, I'm not really sure what to quote for that, because it's basically every case says you have to prove anything you allege.
Thank you, counsel. We appreciate your arguments today. we will take this matter under advisement and issue a decision in due course. We stand adjourned.